Good evening, everyone. My name is Diana Saylor, and I'm an executive wealth manager here at KWB Wealth. Thank you so much for coming. We appreciate it. We're so excited to host our first co-hosted event with Pro Se Legal. And first, I want to just mention that KWB Wealth and Pro Se recently partnered to help our clients and Inland Empire residents with estate planning needs and legal document assistance. And we understand that sometimes estate planning can be intimidating, and so that's why we've created a personalized, seamless, and cost-efficient process. We're very passionate about educating people about the importance of estate planning, and so that's why we're here today. So before we get started, a couple housekeeping items. This presentation will be recorded, and we are taking questions at the end. And so with that, Raina, take it away.
Thank you, Diana. Good evening, everybody. My name is Reina Ventura. I am the Senior Legal Document Assistant for Pro Se Legal. In Pro Se, we help you guys prepare legal documents in different areas of law. My specialty includes estate planning, probate, trust administration, and deed preparation. Today, I'm going to give you guys a little bit of information about what estate planning documents are available for you. And I'm also gonna answer the question, well, what happens to your assets after you pass? Okay, so let's get into the question, what happens to your assets after you pass away? Well, generally, after you pass away, your assets will go to your heirs or your beneficiaries. So who are your heirs and who are your beneficiaries? What is the difference? So your heirs are people who are designated by law, and beneficiaries are designated by you. I don't say people because they can also be institutions or organizations like a church or a nonprofit, for example. So heirs are designated by law, beneficiaries are designated by you. Please note that transferring assets to your heirs or beneficiaries is not automatic. There is always a procedure, okay? The way we determine what procedure to best use in that situation is by asking generally 3 questions. First, we ask, what type of asset are we talking about? Are we talking about a house? Are we talking about a vehicle, a bank account? What is it? We also ask, well, what is the value of this asset? Is it worth $100? Is it worth $10,000, $50,000? Is it worth $500,000? What is the value? We also ask, how is this asset titled? Is it just in the name of one person? Is there a joint owner? Is there a beneficiary listed in this asset? Depending on these 3 elements, we determine which is the best way to transfer that asset to your heirs or beneficiaries. There are procedures that are simple, that are affordable, and that are fast. But then there are also other procedures that are a little more complex, lengthy, and more expensive. In California, the most complex way, the most expensive, and the lengthiest process to use to transfer property from an heir to a beneficiary is by having to go through probate court. So now let's talk a little bit about, well, what is probate? What does that mean? This is the court's definition of probate. So probate means that there is a court case that deals with deciding if a will exists and is valid, figuring out who are the decedent's heirs or beneficiaries, figuring out how much the decedent's property is worth, taking care of the decedent's financial responsibilities, and transferring the decedent's property to the heirs or beneficiaries. Now, what assets go through probate? Well, generally, any property left by a decedent worth more than $166,000 with $250 And if that asset, there's no joint owner or there's no beneficiary, most likely it's gonna have to be probated. So please keep in mind that a probate is not the worst case scenario. It's not the end of the world, but there is other ways to avoid probate. So let's talk a little bit about what happens in a probate proceeding. We did discuss that a probate is the most expensive way. What expenses are we talking about? We're talking about filing fees, court filing fees. We're talking about administration fees. We're talking about attorney fees. We're also talking about debts. Please keep in mind that when a person passes away, the debts do not die with them. So during a court proceeding, creditor, like the Franchise Tax Board, for example, can go to the court and say, this person owes me money. Usually creditors get paid first before any heir or beneficiary gets their inheritance. Okay, so keep that in mind. We also talked about the fact that a probate could be lengthy. Well, what does that mean? A probate is at least 9 months long. In order to complete a probate procedure in court, we need at least 9 months. But depending on the circumstances, it can take years for a probate to be closed, okay? We also talked about the complexity of a probate. Although probate cases are not that difficult, they are complex. And if something is not done the right way the first time, it can make the process last longer and cost more money. So again, it's not the end of the world if we have to go to probate, but there is ways to avoid it. So what is one way to avoid probate? Well, there's one beneficial way to hold assets and also avoid probate, and that is by creating a living trust. So now I'm gonna talk about the different types of estate planning documents that are available, including living trust, and exactly what they are. So a trust, and I'm gonna share with you guys the court's definition of these documents, okay? So a trust is an arrangement where property is given to someone to be held for the benefit of another person. For example, I, Reina, create a trust for my benefit. I, Reina, gave myself my assets to hold in this trust, but I give them to myself as trustee. So now I hold my assets as trustee of my trust. Within my trust document, I designate a successor trustee. A successor trustee will be the person in charge to administer those assets after I pass, and also to make sure that the beneficiaries that I appointed get their share, just like I instructed in my trust. So I instruct who my successor trustee is going to be and who my beneficiaries are going to be. Now, please keep in mind that just creating a trust document is not enough. And that is a big misconception people have. People think I have created the trust, my family is protected. And the truth is there's another step that you must take to make sure those assets are properly protected, and that is titling those assets that could potentially end up in probate into the name of the trust, okay? So now let's talk about a will. A will is a legal paper that lists a person's wishes about what will happen to his or her property after death. So in a will, you list also your beneficiaries, but one big misconception about wills is that just having a will is enough. And the fact is that if you only leave a will and you leave assets that could be probated, they will be. Wills do get probated. They do go through probate court. The good thing about having a will is that you at least get a say as to who gets your assets. As opposed to not having a will, then the court will have to determine who your heirs at law are going to be. Another document to consider within your estate planning is a power of attorney. So within a power of attorney, you can authorize someone to handle a specific task, like signing documents for you while you are away. A big benefit of having a power of attorney is that if you become incapacitated, your loved ones can continue handling your affairs without having to open a conservatorship case. One big misconception about a power of attorney is that people who are agents, people who are appointed as agents under power of attorney sometimes think that they can continue to do things after that person has passed. The truth is, once you die, the power of attorney dies with you. What kind of powers can you grant during with the power of attorney? You can grant broad powers, or you can grant limited powers. So you can say this power of attorney is only available to sell this real property or to handle this matter. You can also say when that power will be effective. You can say this power of attorney will only be effective if I become incapacitated, or this power of attorney will be effective from this date to that date. Okay. Another document that you should consider as part of your estate plan is a healthcare directive. A healthcare directive is a legal document that explains how you want medical decisions about you to be made if you cannot make the decisions for yourself. You can also make end-of-life decisions for yourself. So you can make decisions for yourself as far as to life support, organ donation, and autopsy. It is important that you make those decisions for yourself and not make your family make those decisions. You can avoid conflict between family members. Sometimes family members don't agree as to how to handle a situation like that. So if you leave it in writing ahead of time, you can avoid a lot of conflict, and you can also make sure your loved ones follow your instructions. A common misconception, and I see this a lot, and this is just a general misconception. A lot of parents of adult children think that they have rights over the health care of their adult children. Sometimes they're in a situation where their adult child ends up in a hospital, and this parent thinks, well, that's my child, I should have a say, and that's just not the case. And a lot of parents end up finding this the hard way. So a healthcare directive allows you to direct who is going to be in charge of your healthcare when you become incapacitated or where you just cannot make those decisions for yourself. So this completes my part of the presentation as far as to the estate planning documents that are available to you. Now we're going to have Diana discuss a little bit about the importance of having beneficiaries and also about the importance of financial planning. Thank you.
Thank you, Reina. So you've gone to Pro Se Legal. You have your new estate plan. Now what? Reina explained that you need to identify your assets and re-register them into your trust. But the other thing that you need to look at are your beneficiaries. Have you designated beneficiaries? But first, before we get into what assets you need to designate beneficiaries, why do you need to designate a beneficiary? Here are some common reasons. First off, as Reina discussed probate, we want to avoid probate at all costs. And if your estate is less than $166,250, most often it's going to be a fairly simple process. You fill out a small estate affidavit, and usually institutions move around the assets pretty quickly. So first and foremost, we want to avoid probate. Second, we want to ensure that your assets are distributed the way you wish. You want assets to be distributed to who you want them to go to. Save time and money. So if you have beneficiaries listed, usually that process is pretty easy, but sometimes if you've missed appointing someone or you just forgot, some institutions they will charge you more, or what I mean by save money is taxes. So you just want to make sure that your assets aren't passed on to your estate, and then there are tax implications. And then lastly, just the ease of asset distribution. Those are the reasons why you want to add beneficiaries to your assets. So the next question would be, what assets need beneficiaries? So first off, Reina mentioned that Some assets you can name in the name of the trust, but not all assets you can title in the name of the trust. So retirement plans are one type of asset that you cannot list in the name of your trust. So retirement plans, you need to list beneficiaries. So this would be 401ks, IRAs, Roth IRAs. You want to make sure that you have them listed. Life insurance policies, you can list individual beneficiaries, or you can add your trust as beneficiary to your life insurance policies. Individual investment accounts, so if you have just a non-qualified investment account, stocks, things like that. Why I mention individual is because if it's a joint account, if you pass away, it goes to the joint owner. So if it's individual, you want to make sure that you've listed a beneficiary or beneficiaries, that way it goes to those individuals. Annuities. Annuities are very, very complex. Anybody that has an annuity, I always recommend make sure it's structured appropriately, meaning what is the titling of the annuity? What are the beneficiaries? And believe it or not, every institution's different. So one company, Pacific Life or whatever, any other company, they may do things differently. So you need to know your product, you need to know how to title it, and you need to know who the beneficiaries are and how it's paid out. So I always recommend that everyone reviews your annuity if you have one. Bank accounts, so if you have your trust, you can go to your bank and bring the trust document with you, and you can change the title from joint ownership or individual ownership to your trust. They're getting better about it, but they won't change your account numbers nowadays, which is great. So you can change it into the name of your trust, or if you don't want to do that, you can just add beneficiaries directly to the bank account. They commonly call it POD, pay on death. So you want to make sure you add beneficiaries to your bank accounts. And then lastly, vehicles. I think people forget about vehicles, but if your estate falls under the small estate, it's really not a big deal, but maybe additional documentation. So that's one thing that you can consider. And the other thing is, beneficiaries, there are primary beneficiaries. This is your first beneficiary. And then contingent, which is your secondary. You always want to make sure to have a primary and a contingent, because what if the primary beneficiary predeceases you and you forget and you didn't add a beneficiary? The contingent beneficiary is the backup. So you always want to make sure to have both. How can an estate plan protect your children? So as a parent, that's my first goal always. How do I protect my kids? And when my husband and I had our trust done, it was the fear of, oh my gosh, if something happened to us, we travel a lot together. So what if something happened to us? Who would decide what would happen to our kids? And so really you want to have a trust because you're able to designate what happens to the kids, not the court. I don't want the court telling my kids or deciding who's going to take care of my kids and handle the assets and everything. So it's very, very important. So it's mostly in this case, we're talking about minors. So your adult children, separate story. But it allows you to prevent, really, the court from deciding what's going on. You can also appoint a guardian or a conservator. So that's very important because you want to be able to dictate who's going to take care of your kids. So there's a lot of factors to consider, though, as far as age or location. Are they out of state? Are your kids going to have to move? And are they financially responsible? But the person who's caring for your kids doesn't necessarily need to be the same person who's handling the finances. So that's something that you can list within the trust. Also, you can dictate how they're cared for. Example, college expenses. I want them to just receive monthly income for the living expenses, what have you. You get to dictate that. And then also you get to decide at what age are my kids going to receive the funds. Maybe you say it's age 18. I think that's a little young. I agree. So 18 is a little young, so maybe you say 21 or 25 or whatever, but you get to decide that. It's in the document. So whoever the trustee is, they're caring for the funds and your kids, and they're just making sure that they're well cared for. So that's how a trust can protect your children or grandchildren. So how can you prevent your heirs from being overly taxed? So in this scenario, we're talking about estate taxes. I'm sure most of us have heard about estate taxes. So estate taxes are they are taxes that are paid to the government from your estate. So the process is pass away, they review all of your assets. Raina talked about how debts are paid. So debts are paid, and then what's left over, they figure out what is owed tax-wise. And so right now, fortunately, this estate tax exemption is really high. It's over $12 million per individual and $24 million for a married couple. So for most of us, we're not really going to have to deal with this. But estate tax laws change quite frequently, so it's something to keep in mind as far as your estate size and if you need to make any changes to your trust document. The other type of tax that we don't really hear about or see often is inheritance tax. That's the actual tax that the beneficiary pays in. California, fortunately, does not have an inheritance tax, so that's one type of tax we don't have. So we don't have that, and then it doesn't apply to spouses. So there are some things that people do to reduce their estates so that they don't have to pay an estate tax, and the first would be gifting. So this is gifting assets while you're still living. And so you can gift up to $16,000 per person per year or $32,000 per married couple per year. So some people decide, I'd rather gift them now, maybe they need the money now, so people often do that. The second thing would be fund an irrevocable trust. So an irrevocable trust is a trust document where you are actually relinquishing control of your assets. You are funding it, and therefore, because you are relinquishing control of those assets, it is removed from your estate. So there are all kinds of different irrevocable trusts. It just depends on what your scenario is, but just know that that's an option if your estate is such that you need to do so. And then lastly, donating to charity, that's an option as well. One thing we wanted to mention is the cost basis, step up of cost basis. And so what cost basis is that is the original purchase price of, say, your home or investments. And the reason why this is important to know is that if you pass, there is what we call a step up in basis. Now, there was talks of Congress trying to remove this. It is a very nice thing in that if you pass, whatever the value of that asset is as of the date of your passing, that's the cost or the value that your beneficiaries inherit. So if you purchased the house for $30,000 in 1950 or something, well, now maybe it's worth $500. And if the kids inherit the home and sell right away, there really shouldn't be much gain. So it's a really big tax advantage to your beneficiaries, and the same for investment accounts. Any stocks or bonds or any investments that you may have in those accounts, they receive a step up in cost basis. So it's very important to know that. But why I mention it is that I have heard over the years sometimes the children or whoever will come in and say, should I add myself to my parents' home, the title? Should I add myself to their investment account? And that may not always be the best scenario, because if you add yourself to the home or the investment account, you're now part owner. And so when your parent or grandparent passes, you don't receive the full step up in cost basis. So it's very important that, I know it's to care for them or to take care of things or whatever, but you really have to pay attention to what kind of ownership changes you're trying to make and what potential consequences you may have. Can estate plans really help ease the struggle of losing a loved one? And I would say absolutely. You're already dealing with a lot, right? The emotional toll, family, whatever, there's just a lot that you're dealing with. And so to have everything in place, it just makes the process so much easier. It makes it easier, and then also just knowing who's in control. The court's not deciding what's going on. You get to decide. You've worked so many years for what you have. You want to make sure things are in order. And not just in death, too. I know Raina mentioned it earlier. But with the estate plan, you get to dictate when I'm older or when I can't help myself, this person's going to take care of me, and you have that peace of mind. So estate plans are very important as far as incapacitation, and unfortunately, we see that a lot. Estate plans can also mitigate potential tax obligations, as I mentioned before with estate taxes. That's really the number one goal that we're trying to avoid. And probate, the fees can be very costly. And then lastly, estate plans can help shape the future of your beneficiaries. So it's very, very important. And with that, we're going to go to questions. Raina, you want to come up? Any questions from the audience or questions from all of you on the live stream?
Yes, there's a question.
We did get a question. One of them is, how often should you review your trust?
Good question. So I'll go first and then you can chime in. So as far as how often you should review your trust, usually they say about every 10 years. Or if estate tax laws change, or if there's a change, if you have a change, maybe you want another successor trustee, or you want another beneficiary, or you've decided, you know what, Henry, I don't want you to get the money right away. I'm going to make sure you get it at 25. So any sort of changes that you have, you should review it. So that's what I would say.
Okay, so I have a couple questions for you. What are the tax implications for my beneficiaries if they inherit our home?
So if they inherit the home, like I mentioned before with the cost basis, so what will happen is that they will do an appraisal as of the date of their passing, and then they will also do another appraisal 6 months later, and then you get to use the higher of the two. So if you sell it right away, of course you would use the appraisal that you did, as of the date of their passing, and then it's just the difference of the sale price and the appraised price as of the date of their passing. So if it's quick, potentially no tax obligations.
Okay. Another question for you, Diana. What happens when I inherit a home and then sell it? What is the taxable gain?
So pretty much same answer. It's the difference between the sale price and then the appraised price as of the date of passing.
Okay. Another question is regarding co-trustees. So when you set up your trust, like I mentioned earlier, you designate who your successor trustees are going to be. And yes, you can appoint so 2 people in charge, and you can do 2 people must sign all documents, or you can do either one. So it just depends on the circumstance. Some attorneys will recommend to do it, some might say no, so it's just case by case probably.
And one point on the co-trustee, we get that question a lot. So we have a lot of older clients, and so the incapacitation part or time comes, and so some of the children ask, well, should I take over? So it would be they're still with it enough to sign off and relinquish their control, but some people, they don't want to relinquish control. They want to remain as trustee, but add my child as co-trustee with me. That way we can both make the decision. So that is very common that we see. If you want your child or anybody on there with you, you can add them as co-trustee.
Mm-hmm. Another question is, how do I know if I need a will and a trust? I always tell clients to think of the probate rule. So think of the amount, the value of an asset that could potentially be probated. $166,000 with $250. If you have an asset with that value, and you want to avoid probate, maybe a living trust could benefit you. The number one asset to be probated in California, and this is just from my experience handling probates, is real estate. The second asset most commonly probated are investment accounts. 95% of the cases I've worked with, the probate cases I work with, have been because of a real property. And then the other percent is investment accounts. And then you already went over this question, when should I make updates or amendments to my estate plans? Like we mentioned, as necessary, if there are any changes, if you want to make changes to your trust, if circumstances in your life have changed, maybe you should look into whether your current estate plan still follows your wishes, or if there are any changes that need to be made. So this is an interesting question. Can you have both a will and a trust? Could they work together? So when you create a living trust, there is a document that goes hand in hand with that trust, and that's called a pour over will. So it's a specific type of will. And in that will, you're essentially designating your trust as your beneficiary. I personally call it a just in case document. We use it just in case you left an asset out of the trust. And then we can use a special probate proceeding, a quicker probate proceeding, and we can tell the judge, look, judge, mom, dad intended for this property to be part of the trust. Can we please just help us pour it back into the trust? So when you create a trust, you will most likely have a will. Let me see what other questions we have. Do you have advice for choosing people to be the trustees of my estate if my kids aren't the most responsible?
That's a great question. So if you don't have a family friend or somebody else that you trust to do that aside from your own children, there are institutions that will act as your trustee. We've had that happen with a few clients. So there are institutions out there that will help you.
Mm-hmm. Another question. Should I make the trust the beneficiary to my assets?
Potentially. So I went over earlier that sometimes it does make sense to add your trust as your beneficiary. So for instance, like the retirement accounts that I mentioned earlier, you can't title the retirement accounts in the name of the trust, but you can list your beneficiaries there. Some people have listed their trust as beneficiary of retirement accounts. And so I would say really a couple reasons why you may want to do that is if you wish to what we call rule from the grave. And so basically what that means is I don't want them to have access to funds until 18 or 21 or 25, or maybe my kids aren't financially responsible, so I want to make sure that they get monthly income. So if you're trying to rule from the grave, that is maybe why you would want to add your trust as beneficiary. Or maybe your children or beneficiaries are receiving government assistance. That might be a reason to keep assets within the trust so it doesn't disrupt any assistance that they're receiving. And so really those are kind of the two most common reasons why you would want to add the trust. But what we have found over the years is that adding your trust to your retirement accounts, it does make the process more complicated. So we usually recommend if your trust is fairly simple and you have it just evenly distributed to your beneficiaries or whatever percentages, it's usually better to just list them outright so that they each get their own individual accounts and they can kind of do with what they will.
So another question we have is, what is the average cost to have a complete estate plan? So I can give you guys information about what we do at ProSay. As legal document assistants, we help people create the most basic trust, which is the probate avoidance trust. There are different types of trusts. So depending on the trust you need, that might be the cost. But at ProSay, like I said, we prepare the basic probate avoidance, and our fee is $1,200. And what that includes is the trust document, the pour over will, healthcare directives, power of attorney, and we also draft and record the one deed. So your main residential property, we transfer it into the name of the trust. And I have a question for you. If I wanted to have a consultation in my financial plan just to discuss my assets, how much does it cost?
Good question. Nothing. So here at KWB Wealth, we welcome anybody who would like us to review your situation. We do not charge anything for the consultation. We just, of course, want to educate you, and if we're a good fit and we can help you, we're happy to help.
We have another question. Well, what if I don't have children? Who should I name as beneficiaries? That is, up to you. Like I mentioned earlier, you can name a person as a beneficiary, but you can also name an institution, a nonprofit, a church. So that's just something to help you think about who could potentially be your beneficiary.
Or your parents for
your
now.
Parents.
Until you get
Siblings.
married and then change it or what have you, yeah. Any questions from you all? No? Any more?
I think we got another question, but we already went over that one. We pretty much cover all the questions. No more
Okay.
questions from you guys?
All right. Thank you so much for coming. This presentation was recorded and we will be sending out the replay here soon. So if you have anyone you feel that you want to share with, friends, co-workers, family, anybody who would benefit from watching, we appreciate you passing it along. And of course, if you have any questions for us, we'll be here for a little bit. And for all of you live streaming, you can call us or email us. We're happy to help. Thank you so much.
Thank you.
Thank you.